Then we'll judge at reason that although the recommendation had been made, the appellant had not taken a decision in this regard. The appellant has filed a memo. Enclosing therewith proceedings no, where is the proceedings of the appellant? This is of the working group. This is the proceedings of the working group. Where is the proceedings of the RCI?
My lord, it's on record.
You see the order which was passed on 27/2/2026.
Yes, my lord.
Where is that resolution?
My lord, it is not on record, my lord. So,
We asked you, then you said it's on record. No.
sorry, apology, my lord. My apology.
The Learned Counsel for the appellant seeks further time to place the resolution of the general body, accepting the recommendations of the working group. So a final opportunity is granted to the appellant to do so within a period of 2 weeks from date. List on, put it immediately after 2 weeks.
Much obliged. Much obliged.
13th August.
Kindly,
Much obliged.
they be directed to give me the copy of the writ appeal, my lords.
Take it, ask the counsel, take it from the registry.
Number
They are
7.
from Delhi, my lords.
No, but it must be available. Just ask the counsel, they'll give it to you. Won't have it, just take it from the registry. The pen drive.
But 7 I appear for appellant in this case, my lords. Now I have been renominated in this case, my lords. I am permitted to appear on behalf of appellant, my lords.
Joe?
Please. It's, for easy reference, I have prepared one synopsis, my lords. May pass on this, my lords. God bless. The short point involved in this case is, my lords, whether there is any procedural irregularity or, my lords, lapses on the part of, my lords, the appellant before, my lords, in conducting the, my lords, dope test. Respondent number 1 is a, my lords, basketball player.
Yes.
Lords, he used to represent the country, my lords, in various national and international, my lords, competitions. But he was subjected for, my lords, out competition dope test on 5/2/2022, my lords. His samples were collected in, my lords, 2 samples, sample A and sample B. Lords, sample A received by, my lords, the appellants on 7/2/2022. Same was sent to, my lords, Rome on 16/3/2022. Lords, sample was received by, my lords, the WADA accredited laboratory Rome on, my lords, 22/3/2022. Lords, on 16/4/2022, my lords, the report was received. May I request my lords to kindly go to page 352, my lords, and annexure R1. Lords, this report, my lords, kindly see, my lords, adverse analytical finding, my lords, test result. The result is there, my lords, on the top, immediately after confidential, lords, test report heading. My lords,
Referring to page number?
page 352, my lords. Sample A test is there at page 352.
Yes.
Lords, there, my lords, AAF, adverse analytical finding is recorded, my lords.
Yes.
And in column 3, my lords, sample A is mentioned, my lords.
Yes.
Then, my lords, kindly go to, my lords, additional analysis performed GC CIRM 19 NE. Lords, there, my lords, after 2 lines, my lords, subcontracted analysis FMSI Rome conducted the test for GC CIRMS using the method so and so. See attached test report under the so and so. The sample was analyzed so and so, so and so. Then, my lords, the result of the on the bottom, my lords. Before that, my lords, S1.1 anabolic androgenic steroids AA 19 NE is positive. Then, my lords, results of the GC so and so analysis are consistent with the extragenous origin of NE 19 NE for 19 NE if applicable. This is the report of, my lords, sample A.
Yes.
Then, my lords, the internal review was also conducted, my lords, by the NADA as provided under Article 7.2 as to access, my lords, whether the athlete had applied or granted for any, my lords, therapeutic use exemption certificate. Then, my lords, there was no such exemption application was there, my lords, resulting in, lords, the result of, my lords, sample A test was communicated to, my lords, the respondent number 1, which is at page, my lords, on 26/4/2022.
Yes.
Then, my lords, the respondent number 1 opted for, my lords, test B, sample test B. That test report is at, my lords, page 354. Page 354. Lords, may kindly see, my lords, this test report, adverse analytical finding on the bottom, your lordship can see. According to the current WADA rules, the analysis of the B sample confirmed the presence of non-endogenous 19 NE. The GC so and so results are consistent with the exogenous origin of the target compounds. And, my lords, target compounds also, my lords, percentage is also mentioned. Sample B test also, my lords, tested positive for, my lords, this particular content.
Yes.
Thereafter, my lords, charge was communicated, my lords. Charge memo is at, my lords, page 181, annexure B, my lords. (181), my lords. There, my lords, we have pointed out there is violation of Article 2.1 and 2.2 of NADA rules, and also informed about, my lords, the consequences. Summary of the facts, all we have, my lords, pointed out. Then, my lords, the respondent number 1 athlete, my lords, preferred appeal before, my lords, the Court of Arbitration for Sports, Switzerland, my lords.
Yes.
That particular appeal came to be dismissed for want of, my lords, jurisdiction and also, my lords, maintainability issue. That order is at, my lords, page 239, my lords. Thereafter, my lords, the order under challenge before the learned single judge, one of the order which was under challenge before the learned single judge, my lords, the judgment of, my lords, National Anti-Doping Disciplinary Panel, which your lordship will get at, my lords, page 209, my lords,
Yes.
came to be passed. starts from 187 milots. Operative portion is at page 209. There, milots, the National Anti-Doping Disciplinary Panel, milots, held that, milots, the respondent number 1 is ineligible for, milots, 4 years as provided under Article 10, 2.1, milots. And he was disqualified from all competitive results. Milots, he preferred an appeal, milots, on 7/8/2023. Which is at, milots, page 252. Milots, in the interregnum, milots, by an order, milots, dated 27/10/2023, he was provided with an opportunity to, milots, get pharmacokinetic test and cooperate with the NADA and the testing laboratory to go ahead with, milots, the said test. That order is at, milots, page 308, milots. May I request, milots, to kindly go to page 308, milots, for a moment, milots. Annexure J, page 308, milots.
Yes.
May I read, milots?
Yes.
Pursuant to the appeal filed by the athlete, the appeal panel duly met at the designated time of 4:30 p.m. through virtual mode. During the course of hearing, the appellant relied upon WADA technical document so-and-so dated so-and-so to plead that the athlete has taken a specific plea of consumption of edible parts of intact pigs, and hence in terms of the said technical document origin of 19 NE should be established based on the kinetics of 19 NE excretion. The prayer is not opposed by NADA provided the appellant bears the cost of such testing. Accordingly, the panel allows the plea of the appellant subject to an affidavit being filed by the appellant stating following so and so. In the meantime, then the direction was issued, my lords. Lords, for the best reasons known to, my lords, respondent number 1, my lords, he did not, my lords, undergo this particular pharmacokinetics test. That has been recorded by, my lords, the appellate panel also.
Yes.
Now, my lords, during the pendency of this appeal, my lords, the respondent number 1 prefers writ petition before this honorable court. Kindly see the prayers sought for in the writ petition for a moment, my lords. Which your lordship will get at page, my lords, 169. The original order, my lords, of suspension was under challenge. Then, my lords, alternatively, he has sought for, my lords, for direction to respondent number 1 to comply the direction dated 27/10/2023. That is what I just now I have read, my lords.
Yes.
During the pendency of, my lords, the writ petition, the order of, my lords, National Anti-Doping Appeal Panel came to be passed, which on 16/4/2024, my lords, which your lordship will get at page annexure R1, page 331, my lords, confirming the order of original order passed by, my lords, the disciplinary panel.
Yes.
The said order came to be, my lords, sought to be challenged by virtue of, by way of, my lords, amendment before the learned single judge, and, my lords, subsequently the learned single judge has, my lords, allowed the writ petition and set aside both the orders.
Yes.
That is under challenge before, my lords.
Yes.
The reasons assigned by the learned single judge, may I request, my lords, to kindly see, my lords, the reasons assigned by the learned single judge, which your lordship will get at, lords, page 76, my lords.
Yes.
third line, my lords. The urine samples of the petitioner are collected and placed in a sealed pouch. The sample is said to have been opened and resealed in Delhi, where the testing of urine sample of the petitioner is done at the National Doping Testing Laboratory. What is the test conducted is not made known to the petitioner, nor its report furnished. This is one of the reasons. Then, my lords, kindly go to page 98, my lords.
Yes.
There, my lords, in the middle portion, my lords, after emphasis added word, my lords, the aforesaid finding is rendered based on the test report, which is now appended to the statement of objections. The report reads as follows. I'll skip that report, my lords. Kindly turn out to page 100, my lords.
Yes.
The aforesaid order of the appellate authority is entirely based on the aforesaid noted test. The petitioner attributes presence of 19 Na to regular pork consumption, specifically non-castrated male pig meat, supported by bills and expert opinions. It further asserts that pork would naturally cause 19 Na to appear in urine. It is his assertion that Article 10.6 permits discretion to the authorities to consider no significant fault or negligence. This discretionary mandate of terming the act of the petitioner to be that of negligence is not even considered by the disciplinary panel or by the appellate authority. Before the disciplinary panel or before the appellate authority, as noted herein above, the petitioner had produced evidence with the scientific support. The said evidence does not bear any consideration. This is in violation of subsection 8 of section 22 of the Act, which mandates fair hearing and reasoning required. The disciplinary panel or the appellate authority does not consider the way of sample is the way of the sample is handled. The sample has traveled all over. Section 21 would require accurate, variable, and documented procedure of sample handling. The case at hand is a classic illustration of breach of sample integrity, as is found in Article 6.4 of WADA Code and Section 21 of the Act. Before the appellate authority, Section 22 renders a right to the appellant to present evidence and call for witnesses. This would be the realm of fairness. The appellate authority does not engage itself in any of the mandate of the statute. Therefore, there is complete violation of the procedure stipulated to hold someone guilty of doping. The violation of procedure noted herein above would undoubtedly render the resultant action unsustainable. In the light of preceding analysis, several lacunae in the conduct of proceedings emerged. The petitioner, before the appellate authority, had filed expert affidavits from medical professionals who had opined that exogenous traces of 19 Na detected in petitioner's urine were consistent with the ingestion of meat from uncastrated male pigs and not attributable to anabolic steroid abuse. They are only referred to in paragraph number 17 and 18 of the order. Despite the cogency and credibility of such evidence, the appellate authority in its order renders no meaningful engagement with the submissions, nor it provided any discernible rationale for discarding the evidence so produced by the petitioner. This court is mindful that anti-doping adjudication operates under a regime of strict liability. However, strictness in liability does not mandate callousness in process. The foundational requirements of principles of natural justice cannot be sacrificed projecting administrative expediency. In summation, this court finds impugned orders which culminated in the order of the appellate. So then, my lords, he holds that, my lords, this particular procedure, what is adopted, is not correct. Lords, that finding recorded by the learned single judge is not correct is my respectful submission for two reasons, my lords. May I request my lords to kindly see, my lords, the test procedure which we have to follow, my lords, as per WADA guidelines. Technical documents, what I have produced, my lords, is at the page 213, my lords, annexure E.
Yes.
Lords, to come to the conclusion that, my lords, this particular sample has traveled all over, and my lords, it was opened and resealed. Lords, learned single judge has relied upon, my lords, one document. May request my lords to kindly see page 211, my lords, annexure D.
Yes.
My lords, this is the letter addressed by my lords Nada, dated my lords 16/3/2022. My lords, it is addressed by the laboratory, my lords. I stand myself corrected, my lords. To my lords, the laboratory at Rome. There, my lords, kindly turn out to next page, my lords. Reliance is placed to this clause number 7 at page 212. My lords, bullet point 2, my lords.
Yes.
7. Date and time of resealing. Lords, kindly see on the right hand side, my lords, 15/3/2022 at 4 p.m.
Yes.
By placing reliance on this particular document, my lords, the learned single judge has come to the conclusion that, my lords, this sample has traveled, my lords, all over.
Yes.
Now, my lords, kindly see the WADA document, which is a technical document, which is at page 213, my lords.
Yes.
Lords, this says with regard to, my lords, initial testing procedure. Then, my lords, the procedures to be followed, which is at page 214, 215. Kindly see, my lords, page 215, my lords.
Yes.
Now, there, my lords, immediately after the columns, my lords, GCC IRM's analysis is mandatory on samples in which concentration of 19 Na is estimated between greater than 2.5 and lesser than 15 nanogram ml, except in cases of pregnancy or in the presence of. Then, my lords, kindly see last, my lords, following consumption of edible parts of so-and-so concentrations of excreted 19 Na in urine are usually in low nanogram so-and-so, although higher concentrations have been exceptionally reported. The origin of the urinary 19 Na may not be established by so-and-so analysis, since the varying diets of migrating wild boars lead to dissimilar values which may range between so-and-so. Therefore, if the consumption of edible parts of intact pigs is invoked by an athlete as the unlikely origin of 19 Na finding, this may be established based on pharmacokinetics of 19 Na excretion. Profiles of 19 Na excretion following so-and-so, so-and-so. Then, my lords, kindly see 3.24 at page 217. Interpretation of, my lords, GCC. My lords, this pharmacokinetics test is a method, my lords, followed to study the movement of drug, my lords, in the body. My lords, immediately when, my lords, the athlete is tested positive for doping, lords, he has the option of undergoing this, my lords, test. Immediately after the first test report, my lords, he had an option. He did not choose
Yes.
to provide an explanation as well. Now, my lords, with regard to reporting is concerned, my lords, kindly go to, my lords, page 218 of.
So you're only trying to explain what is the meaning by resealing.
Please.
You started by telling us.
Yes, my
what
lords.
is the resealing
Refilling, my
explanation.
lords. This is the test of what laboratory has done, my lords. At the time of forwarding this, lords, we will not have any control over that, my lords. It is a WADA accredited, my lords, the laboratory, and they will follow their own, my lords, system and procedure. That does not mean that, my lords, it is opened, refilled, and, my lords, manipulated with that particular, my lords. It will be my instructions, are, my lords. There will be around.
This is not done by. It's done by you.
My lords, this is a
This is a
dope testing laboratory.
This is a letter written by you.
This is the
To the Laboratory at Rome.
Rome.
Right.
This letter is addressed by the National Dope Testing Laboratory, my lords, not by us. Now, my respectful submission is, my lords, the laboratory being, my lords, WADA accredited laboratory, they will have their own system and procedure, my lords. So,
Yes.
my lords, my instructions are, my lords, all these tests will be done, my lords, in camera, and there will be, my lords, more than 25 to 30 officials who will be, my lords, present at the time of conducting these tests. Now, my lords, insofar as the procedure and the presence of, my lords, concentration is concerned, this technical document specifically speaks, my lords, at page 219.
Okay.
My lords, this particular athlete comes under, my lords, 4.3.
Yes.
Page 219, my lords.
Yes.
My lords, male or female athletes, neither pregnant nor using northeastern. Then, my lords, adverse analytical finding is at second column. Then atypical finding is at third column. Negative findings is at fourth column.
Yes.
Then this, my lords, comes, kindly see, estimated concentration of 19 Na. Less than 15 nanogram. And so at so and so. Lords, then estimated on the fourth column, my lords, concentration of 19 so and so. This is again 15 nanogram. Now the chart, my lords, is available at page, my lords, 222. What is the procedure? How this flow chart will work?
Yes.
Page 222, my lords. Male on the right hand side, my lords.
Yes.
Immediately after that, sample from the male or female, 4.1 and 4.2. 4.3, I'm sorry, 4.3. Then, my lords, what is the nanogram of this particular concentration? Then endogenous, inclusion, or exogenous. Then, my lords, in the present case, my lords, the particular consumption, as my lords confirmed, and it is by sample A and sample B test, my lords, it is exogenous. That shows, my lords, it is adverse analytical finding. That being the case, my lords, my respectful submission is, my lords, there was no, my lords, basis or the learned single judge, my lords, by observing that, my lords, there is procedural irregularity, has proceeded to pass this particular order, which is not correct, is my respectful submission, my lords. Now, my lords, insofar as procedures, what is to be followed is concerned, my lords, Article 6.7, my lords, of National Anti-Doping Agency Rules 2021 are concerned.
Yes.
6.1, my lords, speaks with regard to, my lords, use of accredited approved laboratories and other laboratories. Article 6.1. Then, my lords, Article 6.7, my lords, how to collect the urine samples split into A and B samples, following international standard of laboratories, specifically, my lords, shows 6.1 and 6.7 are, my lords, relevant here.
Yes.
6.1, I'll not trouble by reading, my lord. 6.7 as well. Insofar as, my lords, the role of, my lords, the athlete is concerned, Article 2.1, 2.2 specifically states, my lords, what is to be done. 2.1 and 2.2, my lords. It is the athlete's personal duty to ensure that no prohibited substance enters their bodies.
Yes.
Prohibited substance enters their bodies. Athletes are responsible for any prohibited substance or its metabolic bolets or markers found to be present in their samples. Accordingly, it is not necessary to intent, fault, negligence, or knowing use on the athlete's part be demonstrated in order to establish an anti-doping rule violation under Article 2.1. Then, my lords, 2.1.2. Sufficient proof of an anti-doping rule violation under Article 2.1 is established by the following presence of prohibited substance or its metabolites markers in the athlete's A sample, where the athlete waives analysis of B sample and the B sample is not analyzed, or where the athlete's B sample is analyzed and the analysis of the athlete's B sample confirms the presence of a prohibited substance or its metabolites or makers found in the athlete's A sample. Lords, here is a case where, my lords, A sample as well as B sample tested positive for prohibited substance found in the body. Now, my lords, athlete had an option, my lords, kindly go to Article 4.4 for a moment, my lords. Therapeutic use exemptions. He had that option also, which he has not chosen to. Lords, per contra, he took up a contention that, my lords, he had, my lords, consumed fork after prolonged period. And due to the eating of edible parts of non-castrated male pig. My lords, when he had an option to undergo, my lords, pharmacokinetics test, he has not opted to do so. Then, my lords, sample A and sample B tested positive for this. Then, my lords, even when the appeal was pending for consideration, he preferred writ petition before this honorable court. These documents, what I have placed reliance, my lords, clearly shows, my lords, he has consumed the substance, prohibited substance, resulting in, my lords, passing of these two orders. My lords, insofar as
Yes.
anti-doping panel's decision is concerned, my lords, I'm placing reliance on, my lords, decision passed in Delhi High Court at, my lords, page 380. Of course, my lords, by single judge, my lords. Relevant is at page 382. Para 8. This court does not find any testimony that was submitted before the disciplinary panel or appeal panel by the third party confirming the petitioner's defense. Insofar as the extent of punition imposed on the petitioner is concerned, this court is not inclined to interfere with the same. This is a matter of for the administration of the sport bodies, and no interference under Article 226 of the Constitution of India would be warranted unless it is established that the action taken is mala fide, capricious, or otherwise violates the constitutional guarantees. In the present case also, my lords, the usage of prohibited substance is substantiated, my lords, by 2 reports. And the report clearly says, my lords, it is exogenic. My respectful submission is, my lords, the laboratory has not merely detected, my lords, the presence of 19Na. Lords, but the laboratory has also conducted, my lords, the requisite tests as prescribed under, my lords, WADA technical documents. The same as, my lords, conclusively established and detected, my lords, metabolite which was exogenous in origin. That being the case, my lords, merely because there was one observation sealing and, my lords, resealing, that cannot be a ground for, my lords, allowing the.
But sealing of the entire sample, not sample A and B.
Please, I'm sorry, my lords.
You have sample A and B.
Yes, my lords.
But this was pre-sample A and B or post-sample A and B?
My lords, it is sample was taken in 2, my lords, samples, 2 vessels.
So this is sample A that went there.
Both samples, sir.
No, when you say resealing and resealing, this is which sample?
Sample A. First, my lords, it will be tested for, my lords, the presence of 19Na.
No, this.
Then it is to determine, my lords, whether it is endogenous or exogenous.
No, determination
test.
comes later. What is the flow chart of how and when the samples were collected?
My lords, a sample was. May I request, my lords, kindly take the synopsis, my lords.
Yes.
Lords, sample was collected on 5/2/2022.
This was only one sample.
Both samples, A and B. And on 7/2/22, it was sent for testing to National Dope Testing Laboratory. Then, my lords, from National Dope Testing Laboratory, it was sent on 16/3.
No, this sample which this report which is being faulted, you're
Yes.
being faulted for, is sample A.
352 is sample A.
No, 352 is sample A.
Yes,
It was sealed and resealed. Then sample A was sent where? To Rome.
Rome.
All right.
Both the samples were sent to Rome.
No, but this, according to you, this sealing and resealing is only in sample A.
My lords, this resealing, my lords, page 211. This is with regard to, my lords, documentation shipping A and B.
So both were opened and sealed.
That is what it shows, my lords, of sample A and B at page 212. Lords, this opening and resealing was done by lab by using the machines, and lords, this particular vessels cannot be opened or, my lords, used by, my lords, human intervention. This will have to be done, my lords, because that is what the WADA technical guidelines says.
Which is a procedure that involves opening and sealing and resealing. The national dope testing,
That is in WADA procedures, my lords.
where is that?
that lab will follow, my lords.
You'll have to show us this, your appeal, there's, the learned single judge has held that this is
This particular
a flaw in
procedure,
the procedure. So you, the least that you have to do is to show, no, this is a part of the procedure.
this particular document, my lords, the procedure followed by the laboratory is not, my lords, a part of the record.
You show the record. What is the procedure followed and what is the procedure they are supposed to follow? Obviously, there is a resealing verification of sample A or B.
So there is a WADA international standards for, my lords, laboratories. As per that, my lords, the
No,
procedures.
this is obviously something to do with format for verification and for dispatch of sample A
That's right.
for subcontracting. This
Yes.
is some process of subcontract.
Yes. Here, my lords, previous page 211, my lords, communication. The letter, my lords, dated 16/3. As per the communication with the testing authority, so and so is sending the human urine sample to your laboratory for testing by GCCIRMS to conclude the origin of 19NA, whether endogenous or exogenous, as the method for so and so is not part of our NDTL. Having the service of PDP courier for sending the human urine samples to your laboratory, there is only one sample set of A and B, which will be transported to your laboratory at a controlled temperature of 2 to 8 centigrade. Upon receipt, the filled in acknowledgement so and so temperature data logger details may be sent back to so and so. Documentation of shipping is detailed.
This sealing is done in presence of the sports person. No. Is it done in presence of the?
No, this is done by the laboratory.
You see, there is a director,
Quality manager in charge so and so, and sports person observer. His signature is not there. The issue is, my lords, whether the sample tested positive for 19NA or not.
they are saying that there is the integrity of the sample has not been maintained.
Lords, now
That's
if that is the
that's
case, my lords, nothing prevented him from, my lords, undergoing a pharmacokinetics test.
No, that's a separate issue.
No, my lords.
All right,
Because in fact, on that pharmacokinetic test, I followed up and said, I'm willing to pay. They said there's no laboratory after some time. And the appeal panel completely disingenuously ignores the fact that I am willing to undergo, and then it turns its head and said, you didn't identify a lab. I'm not supposed to identify a lab. And they're supposed to conduct the pharmacokinetic test. I'll point that out also. Before that, kindly see Annexure A, 174, page 174.
Yes.
Kindly see who it is addressed to. Mr. Shashank Rai is in the address. Then, dear Miss Shashi Yadav.
A clerical mistake, my lords. It's addressed to correct
And the learned
person.
single judge extracts this order also in his order, my lords, to show this is also a problem.
Sample number is correct, my lord. Sample number is same.
My lords, that's one, my lords. Then, my lords, this pharmacokinetic test. My lords, kindly see.
So where is the provision for having this extra test done?
My lords, that the anti-doping appeal panel said. My lords, that's what my learned friend also said. That he read out the provision, my lords, that pharmacokinetic test, which I should have offered to undergo.
No, let's see where does it.
My lords, can I, my lords, then request for some time? I'll file there because, my lords, some papers are also missing, which were noticed in their appeal. I'll file everything, my lords.
See, it can't, whatever happens at the later stage. I mean, tomorrow anybody might say that we want witnesses, we want X, Y, Z. But this is not the kind of a exercise
No,
that needs to be done.
I'm fully with you.
If it's part of the rules,
If it's part of the rules, we have to undergo.
then
Yes, my lords. My lords, see, if what I understand, my lords, my learned friend informs me, what I understand is once a contention is taken that it's an endogenous reason, then the pharmacokinetic test is the only test that determines whether it's endogenous or
even
exogenous.
pharmacokinetics is actually a study on how the drug passes through your body.
Yes, yes,
But then it has to have other details.
yes, my lord.
We don't see any details of when did you ingest the
Because we have produced all that before the appellate panel and before the hearing panel. We have produced everything.
time and date when you ingested it.
Yes, my lords. Yeah, everything. In detail, we have produced it. That is what the learned single judge also notes. The evidence that we have produced is not even there. And my lord, some of it is not on record, which is why my learned friend said we'll produce everything.
Learned counsel appearing for the respondent seeks time to file the
That's
seeks time to submit the relevant documents, also address submissions. List.
may I request, my lords, the question of my lords, we offering pharmacokinetic test comes only when, my lords, he offers explanation.
Yes.
Here in
That's
this
on
case, my
record.
lords, he has not done so.
Because the anti-doping
And, in the
appellate panel
charge-
and the anti-doping panel both recorded. I will
And
show
in the-
that.
In the charge itself, my lords, I'm sorry.
Sorry.
In the charge, in the charge memo itself, my lords, we have stated you have not offered any explanation. Now, after 6 months, my lords, he says, no, I want to undergo pharmacokinetic test. What will be there in the body, my lords, after 6 months?
No, the pharmacokinetics is how much time does it take for the body to retain it. So
Yes.
you'll have to first find a uncastrated pig.
Big, my lords.
Then you'll have to possibly,
No, he has admitted, my lords, so he has consumed that.
no, his explanation that he has consumed it, and because he has consumed that, possibly this extraneous substance has come through that route.
That is the only question.
How will you find?
My lords,
But he has not-
my lords, the learned single judge with my lords goes only on the procedural violations.
That all of the uncastrated pigs have this particular document, have this compound.
My lords, I believe, my lords, what I understand, my lords, I'm also trying to read up on that particular issue. I believe, my lords, it depends on the frequency with which you are consuming and whether at that time. So what?
And test is that if you want to show that you haven't taken the drug
Yes.
and this has come during this method,
Yes,
you
yes,
repeat
yes.
that in controlled environment.
Yes, control.
And
Yes.
therefore you come to know that yes, this theory is accepted
Yes.
and done. So that would have to find the substance that you've taken.
Yes.
Supposedly you've taken some other drug, and then there is a comparison
Yes.
that if you had taken that,
Caution.
this would have
Yes,
resulted
yes.
in this.
Yes.
First of all, you're doing it at anterior point of time at 6 months. Second is that you have to first find out that substance which you say for you to take a control test. And then you must have to find that pig's brother or somebody else like that, because you can't, unlikely that you'll find the same substance. Unless you say that this substance is present in every
Yes, my lords.
case.
Yes, my lords.
Even that assertion is not there.
My lords, I will show all the relevant details. My lords. I'll show the affidavit that we have filed. My lords, in fact, the detailed bills, everything we produced. And I followed up for the pharmacokinetics. That's the only point I wanted to make. 309 shows that I am following up for the pharmacokinetic test after the appellate panel ordered me.
You have to see whether it fits into your scheme.
Yes, Manoj.
Otherwise, if we permit this,
Yes.
then there'll always be these tangent issues that will crop up.
Yes, Manoj. Manoj, anyway, Manoj, in terms of the 4 years, it's expired. I have suffered the consequences already. It expired in April itself.
4 years, insofar as that contention is concerned, my lords, by virtue of my lords, on order dated 5/4/2024, he was allowed to participate. That shows, my lords, only 1 year, 11 months he has, my lords, undergone. Not,
Today, now,
No, to
four,
the contrary.
you can't undo an interim order.
my lords, ultimately, my lords, if at all, if that was the reasoning, my lords,
If we find any law in this, we may set, by consent, set aside this order.
lords, that provision is there, my lords, under Article 10 also.
That
You kindly see, my lords, Article 10 for a moment, my lords.
yes,
10.2, my lords.
yes.
Ineligibility for presence of use of attempted use and or possession of so and so. This can be reduced to 2 years, my lords.
No, he's completed it. You could only now, if he's completed his punishment, then the only value that this appeal has is perhaps on a precedent value. That's all that you,
Yes, Manoj.
what else is there?
Lords, now my
Assuming you were to succeed and this order is set aside, what impact would it have to him?
my lords, say he will have to, my lords, undergo another 2 years, my lords. Otherwise, now by virtue of
Where do you say he'll have to go under 2 years?
now, my lords, 4 years total.
Where does it say that he has to go 2 years, that if there is an interim order in between?
No, interim order was, my lords, for permitting him to participate.
That's all right. So today there is a order permitting him to retire.
Yes.
That doesn't mean that his punishment gets extended.
No.
It's not like that he is out of the, now his incarceration is not complete, you put him inside. That's not the principle that you apply.
7.4.1.
7 point?
4.1. That's it says, my lords, so provisional suspension for entire period when the proceedings takes place. And it can be eliminated only under, my lords, 2 categories. That is that, my lords, a mandatory provisional suspension may be eliminated if the athlete demonstrates to NADA's hearing panel that the violation is likely to have involved contaminated product. The violation of
You are saying today his 4 years are over, your punishment is over, that is now debarred from X period to X period. How will you enhance that punishment? Where is the provision for that?
Lords, at the most, my lords, sir, learned single judge could have, my lords, invoked the Article 10 subclause 6.
And therefore we can set aside the order.
And
But you can't undo that. No, you can't make him unparticipate in a
now
event that is
my
participating.
submission is, my lords, now virtually by virtue of, my lords, the order dated 5/4/2024.
Yes.
Now, whether he can continue, he can take exemption of that period or not, is, my lords, will have to
Not an exemption. Let's see your punishment. Where is your punishment?
punishment
imposed?
order.
Where is the order impugned?
Please. Page 209 minutes. Para 46 minutes. It is clear that the benefit of Article 10.5 cannot be granted to the athlete as the ADRV was intentional and violation of being out competition is an irrelevant fact given so and so and so. Last minutes, we accordingly hold that the athlete is liable for a period of ineligibility of 4 years.
Yeah, so 4 years is liable for a period of ineligibility 4 years.
4 years.
It's commenced.
But now, my lords, the rule says, article says,
Yes.
he should be suspended from all games.
He says, so whatever else is taken away, whatever his credentials are during this period will go.
The Article 7 reads otherwise, my lords.
What does it say?
Impose a provisional suspension, which is what is correct. Office provisional suspension. This particular provision says, my lords, so mandatory provisional suspension order can be eliminated under with circumstances, and it can be done.
We are asking, where does it say that if you have, that as far as suspension is concerned, that is pre-punishment, that credit you have given.
Lords, so that this particular article, my lords,
Then
there is no,
how will you come to the conclusion
there is
that
no reference as such, my lords.
this, it's not as if that suspension, disqualification has been set aside.
Now, virtually, my lords, the learned single judge has come to the conclusion, my lords, with the procedure what we have followed.
Therefore,
That is not proper. Then it will have, my lords, bearing on, my lords, all the almost similar tests what will be conducted by, my lords, the laboratories. Without undergoing, my lords,
take instructions, we'll keep those questions open, but
Yes.
this punishment is over, it
Yes,
may
yes.
just be academic.
question is, my lords, without undergoing, my lords, the requisite tests.
Go on, he's undergone the whole position, he's
No.
only got one interim order on which he's
Yes.
participated
No,
in one.
without undergoing, my lords, the requisite.
Events has he participated in?
Subsequently, that instructions I don't have, lords.
How many?
Was in fact, even after the learned single judge granted some relief, they did allow me to play for a while. We'll come back, my lords, with the exact details.
Another issue is, my lords, whether writ petition is maintainable when appeal was pending for adjudication, my lords.
Maintainability, writ petition is maintainable at all stages. Writ petition is maintainable in all stages. 226 doesn't bind in,
No, my lords,
doesn't say that it's not maintainable if the proceedings are pending.
parallel proceedings, my lords, simultaneously.
So the court may decide not to entertain it. That's a separate issue, but maintainability, don't conflate maintainability with whether it should be, whether the writ petition ought to be entertained. These are constitutional remedies available. Can you say that Article 32 will not be available because of the proceeding?
I'm not saying so, my lords, but so far as I'm again taking my lord's order of my lords Delhi High Court, where my lords held.
Whether you should entertain it or not is a separate issue.
Yes, my lords.
Whether the court should entertain it, and this is normal. Everybody argues whether that it is maintainable, not maintainable. Writ petition is maintainable, but there are principles on which you should
Entertain
it. That's all.
Yes, my lords. Insofar as that punishment is concerned, I'll come back, my lords.
So, this for further proceedings.
7 September.
Could it be taken up next week or week after next itself, my lords? It can be, since it's in a narrow compass, my lords, now.
Yes, we'll take it up. We have said it's parted here. We've said further proceedings. Get your.
Cell number 8.
Grateful.
Direction
The
is.
accused has filed the affidavit in this matter. My lord. instruction is to consider the representation in terms of the government order dated 17/5/2025. Government order is to reserve 4% to in promotion to the disabled person. But instead of considering the case, they have issued endorsement. Is produced at annexure C, under which my request has been rejected. Annexure C is the endorsement issued by the.
May I submit one?
Yes.
No, the direction is to consider the representation for considering the promotional post under the 4% disabled quota. We have issued the annexure C, my lord, page 22, translated copies at page 24. May I read now? Page 24 is the endorsement issued pursuant to the order of the writ petition. Fifth line. Upon review, the lordship's got it.
Yes.
Upon review, it was observed that the High Court judgment dated 1/8/2025 reference 7 directs that your previous application dated 23/6/22 for promotion to the post of Assistant Director under the PWD quota shall be considered as per the rules in accordance with the government order under reference number 4. Upon review, it was noted that the government order reference 2 mandates that roster points 5, 30, 55 and 82 are to be considered for granting promotion under the persons with disabilities reservation quota for posts from group C to B and group B to A, junior scale. The government order in reference 4 further specifies that if promotions have already been granted, the rule must be implemented starting from the points immediately subsequent to the last point utilized for promotion. Accordingly, an examination of this office's order under reference 3 shows that roster point 9 was the last point used while granting promotions to the post of Assistant Director. Therefore, it is hereby communicated that the endorsement of this office already issued on 18/6 under reference number 5 is affirmed in accordance with the judgment delivered by the High Court on 1/8/2025. It states that your request will be examined as per the rules at the time of granting promotion to the post of Assistant Director based on the availability of the post. We have filed the affidavit, my lord, and the departmental promotion committee meeting.
If this endorsement is considered, he will not get any promotion.
But that you'll retirement. That you'll have to.
My lord, before the writ petition order, the departmental committee promotion committee DPC meeting was held on 29/11/2024. And as on that date, there were 5 vacant posts in the residual parent cadre for the post of Assistant Director. It's shown at page 17 along with the affidavit file. The copy of the DPC meeting, your lordship's got it. Page 17 is a translated copy. So 5 posts were available. And as per the seniority, they've been filled. And the roster point 5.
Filled up by a person senior to him.
Please, my lord, page 20 is the list of candidates who have been selected for the promotion. As per the seniority, 211, 218, 228 and 219 at second column. Page 20 and 21.
You'll have to take your remedials.
So the petitioner's seniority stands at 236, my lord. And in the next round of vacancy.
This order, DPC was not it.
No, they've examined your representation in the light of the government order.
Well, when the next round of vacancy arises, he will automatically get the promotion.
Challenge if you are aggrieved by this order. The complainant is filed the present.
We will explain that at page 5 of my affidavit.
Complainant alleging willful disobedience of the order dated 1st August 2025, asked by the then coordinate bench of this court in writ petition number 23560 of 2023 bracket S dash KS80 bracket close. This court had directed. It set aside an endorsement dated 21/2023 and it directed the respondents to consider the complainant's representation dated 23/6/2022 in the light of the government order dated 17/5/2025 and pass appropriate orders in accordance with law. The accused is filed in compliance affidavit affirming that the position that the complainant's representation to accord him promotion as an assistant director under the quota reserved for differently abled government servant was considered. Good stuff. It is from that he said that the motion of differently abled persons are to be considered against roster points 5, 30, 55, and 82 in a cycle of 100 roster points. The next roster point is the roster point number 5 has already been filled up, and the next roster point available is 30.
30.
30. An endorsement of this effect has also been issued. So in view of the above, the present complaint is closed. We have, in the event the complainant is aggrieved by the endorsement or by the stand of the respondents, this order will not preclude this order will not preclude the complainant from availing substantive remedies, albeit in accordance with law.
This still number 9.
Obliged.
For the complainant in number 9 to 19, the respondent KDB has complied with the order of the single judge.
All of them we have issued. The order was assailed before Supreme Court, my lords, it was dismissed. Pursuant to which all of these allotments have been made. Please.
You've taken time to confirm the same.
Please.
He confirms it.
Please.
Learned counsel appearing for the complainants, these batch of complaints. And he confirms that the order, the disobedience of which is alleged, is complied with. And the complaint may be disposed. Complaints may be disposed. In view of the above, the complaints are closed.
From 9 to 19, my lords.
9 to 19.
9 to 19. Deeply obliged.
Still number 20.
We filed the
Still number
complaints
20.
application.
Srimati Bharti M.
None appears for the complainant in the interest of justice.
Well, we already filed the complaints affidavit, and the endorsement has been issued pursuant to the directions of the writ petition order.
Nobody is there. It's interest of justice. Renotified.
18 September. Still number 21.
As per the decisions of the Honorable Court, single judge, they are not at all effect kata in favor of the.
Yeah, the panchayat has to comply with the order in this matter for registering the khata. Panchayat is represented by the panel advocate.
Who is to Nobody is appearing for the panchayat. And appears for the accused in the interest of justice, re-notify.
Son. 7th October. So number 22.
That's serial number 21.
Yes.
Okay, for accused Millers.
Yes.
Accused Millers. Now PD has been changed Millers. Complaints
break.
affidavit is ready Millers.
Take it after 24, you catch up. You just hold it over.
Short date will.
He
Only
wants to say
affecting
something.
Kata. That's what affecting Kata only that matters.
He wants to say something, no?
PDO is transfer now. PDO is earlier PDO is transferred. Now is Sandeep is the charging.
He's not made a party to this proceedings Millers.
Then you make him a party.
File a memo also Miller in this regard.
Memo.
Earlier PDO is transferred. Now with charging the one Sandeep K.
So you'll have to change the memo, no? You're saying this is for our information.
Please.
Learned counsel appearing for the complainant seeks time to complete the current incumbent of the Panchayat Development Office. You take instructions.
Please.
Learned counsel appearing for the said accused seeks time to take instructions.
7th October. So number 22.
People responding.
Mr. Mahesh, yes.
We filed a review petition, Lord. Was listed yesterday. Lordship have listed it tomorrow also. Against the order of the 11th single judge. Sought for a review of the order, Lord. Was listed yesterday. Will be listed tomorrow again.
None appears for the complainant. This stated that a review petition has been preferred, which is now listed tomorrow. Accordingly, list on.
3rd November.
Please.
Number 23.
And for the complainant. The complainant had sought for the.
We filed the compliance affidavit in this matter. Now, the direction was to reconstruct the documents pertaining to the grant and issue the certified copies after obtaining copies from the petitioner. The petitioner was not able to provide the original documents pertaining to the grant and the challan, which are the mandatory requirements for restructuring and restoring the documents. Therefore, we have issued an endorsement that in the absence of the original records or the restoration challan, we are not able to reconstruct the documents.
Lordship had furnished all the documents that are available with him.
Direction is given to respondent for to procure the original documents. To the extent available and possible, and issue certified copies.
Please, ma'am. Petitioner is directed to cooperate with respondent number 4 and furnish all the records, documents available with him for the aforesaid purpose. At page 30, your lordship should get. At page 30, line 3. In our affidavit, we have mentioned, my lord, that.
Lordship, at page number 70, along with the letter, I have produced all the documents available that are with me. Page number at the translated copy is at 72, my lord. Annexure M1.
And I have also made a letter appraising the fact that I have produced or furnished all the available records, and to furnish the and to or to reconstruct to the extent possible.
May I draw your lordship's attention to para 5 of the affidavit? I submit that during the course of such verification, certain limited records such as mutation extracts and related entries were found available in the office and the same were duly considered. However, it was noticed that the essential foundational documents required for reconstruction of the original file were not available in the office records.
What are the documents that you have?
Sorry, my lord. I have produced the along with the page number 72, my lord.
Only the mutation extracts have been produced.
No,
by
my
the
lord. Even the record of rights and form number 1, page number 72. My lord. Akar Band and MR. Whatever the documents that are available with me are have been produced. Even in the MR extract, my lord, there is a specific mention at page number. Page number 32, my lords. In the column, in the second row, Khata has been restored as per orders of the Amaldar dated 13/12/1945. That is what the document, it's a permanent document. Your Honor. On that basis only the learned single judge has directed them. And even the assistant commissioner has also given a direction. Your Honor.
Given you more than just MR entries.
No, the original grant records or the restoration order should be available in the office, which is not available and the petition is not able to produce.
What do you do? You're not,
In the absence of the original grant records, it's not.
Your Honor, they are asking the same document which I have sought for under the application. If I had that copy, Your Honor, I wouldn't have filed that application.
I'll seek further instructions and.
it can't be. You're supposed to keep records. Now you have to reconstruct them. If you're saying we can't reconstruct records.
No, at least in the index, if the mention is made with respect to the grantee, they will reconstruct the record. In the missing committee.
He's giving you a carbon, he's giving you your entries in your land records.
I will seek instructions.
If you accept this, then there won't be any records available in any case.
The affidavit states that the restoration order and the grant records are not available and the petitioner has also not been able to produce it. I mean, I will further.
Orders, land records, right, RTC records from 3031 onwards.
I will secure instructions.
The council appearing for the accused has filed a compliance affidavit, which is confirming that the records cannot be, that the directions, the records cannot be constructed. It is not possible to construct the records, reconstruct the records. On a face, it's difficult to accept it. The concerned authorities would be unable to reconstruct the records from the available documents. Learned counsel appearing for the Q seeks time to take instructions. This
Short date.
September. Number 24.
With the lordship's permission, I file the compliance affidavit.
Then appears to be complaining in the interest of justice, denotify. Put a short date. Do it next week sometime.
So, on 6th of August. Number 25. Chandan Goda Patil.
Same. appears for the main person there.
It's on 8th of October. It's number 26.
IFF accused 5 to 10, my lord. My lord, they have served this incomplete set of papers only on Monday, my lord. I'll prepare my objections and file it. Some time may be granted.
Gone through the court, my lords. I apologize, but if it is incomplete, I'll serve another set.
Completed. Learned counsel for appearing for accused. You're appearing for accused number?
Yes, my lord.
You're appearing for accused number?
5 to 10, my lord.
5 to 10. It's it. He was received in, he was served on earlier this week, and the papers are served are incomplete. There is counsel for the
But
complainant.
Mr. Charity may be directed to take notice in these PDA matters.
Shall serve a complete set of papers.
I'll serve a fresh set.
List on that.
Mr. M.V. Charity.
We'll be appearing for respondents number.
Lord, A1 to A4, my lord.
A1 to A4, BDA.
Somebody else has filed it.
Yes.
Yes. 21st September.
21st. I'm grateful.
Mentioned matters. List ones number 42. Number 42.
None appears for the petitioner list.
24th September. Number 43.
The last occasion, the lordship was pleased to direct the government
My lord,
to seek instructions
my lord,
as to
insofar
whether
as
the procedures have been followed before declaration of safer zone. In this matter, my lord, declaration was done.
So, my lord, insofar as declaration is concerned, my lord, there is no irregularity, my lord. We have followed the joint inspection. That is what is contemplated in the act, my lord.
Public notice.
My lord, public notice is not contemplated for declaration of safer zone, my lord. What is required is under section 6(3), my lord, a joint inspection by the officials of various departments, my lord, forest, environment, and mining department. That procedure has been contemplated under the act. That has been followed, my lord, insofar as declaration of safe zone is concerned.
After issuance of Form B1, declaration of safer zone and notification, no discretion is left with the licensing authorities, not they have to issue Form C. In the similar circumstances, your lordship was pleased to direct the licensing authority to grant Form C license. May I pass on this? Because this is second round of litigation, Lord. In the earlier round, we have filed a writ petition seeking direction against the authorities. Lord, contempt was also filed.
Yes, what is your response now?
My lord, if Lordship is inclined to quash the annexure B, my lord, that is the cancellation of Form B, my lord.
No, so
Annexure B is the safer zone notification, my lord, Form B. Recommendation for form.
it's been cancelled on.
My lord, the
Can't have a
cancellation,
safe-
my lord, after safer zone notification and before license could be issued in Form C, my lord. Because of certain complaints that have been received, my lord, that we have filed our statement of objection. We have received certain complaints based on which they have acted under Section 10, my lord, which provides for cancellation of a license. We have invoked that provision to.
Section 10 is not at all applicable, my lord, because
It's not
science
applicable in
license
so
itself
far as
is not-
cancellation of safer zone is concerned, my lord, but that is the procedure contemplated for cancellation of a
Technically,
license.
right, section 10 may not be applicable because you don't have a license as yet.
Yes.
But tomorrow, if you get a license, then they'll do the
Not
same
a
thing.
subsequent complaint, Lord, will not renew the authority to cancel the license. There is a provision under Lot 63.
Well, we'll hear your matter tomorrow. We have a partner.
Please, my lord.
Take it. This
Yeah,
time,
request
List
on the
number
top
two.
of the list.
yes,
Top of the list tomorrow.
come tomorrow, it will come in
Yes.
automatically in there.
List number 2, seal number 23.
Yesterday, Marosa is pointing out the need to introduce as a condition precedent for operating the reservation, a post-based roster as held in RK Sabharwal. Then Marosa, I was to take my lords to a few paragraphs in M. Nagaraj, where it is said, my lords, the power to reserve cannot be operated without introducing the post-based roster. If my lords could kindly turn to volume 2, my lords. Judgment in M. Nagaraj starts at page 612. Para 68 at page 667, my lords.
Yes.
However, in RK Sabharwal, which was a case of promotion and the issue in this case was operation of roster system, the court stated that the entire cadre strength should be taken into account to determine whether reservation up to the required limit had been reached. With regard to ruling in Indra Sani's case, that reservation in a year should not go beyond 50%, court held that it applied to initial appointments. There is not the direct recruitment with which we are concerned. The operation of a roster for filling the cadre strength by itself ensures that the reservation remains within 50% limit. In substance, court said that presuming that 100% of the vacancies have been filled, each post gets marked for the particular category of candidate to be appointed against it, and any subsequent vacancy has to be filled by the category candidate. The court was concerned with the possibility that reservation in the entire cadre may exceed 50% limit if every year half of the seats are reserved. The Constitution, the 81st Amendment, added 16(4)(b), which in substance gives legislative assent to the judgment in R.K. Sabharwal. Then, my lords, proceeding further, it said, my lord, that now legislature has also approved R.K. Sabharwal, and R.K. Sabharwal has become the coalesced law, both between the judiciary and the this one. Para 82 at page 675, my lords. Yes. Para 82, my lords. Before dealing with the scope of constitutional amendments, we need to recap the judgments in Indira Sane and R.K. Sabharwal. In the former case, majority held that 50% rule should be applied to each year. Otherwise, it may happen that the open competition channel may get choked if the entire cadre strength is taken as a unit. However, in R.K. Sabharwal, this court stated that the entire cadre strength should be taken into account to determine whether reservation up to the quota limit has been reached. It was clarified that Indira Sane was confined to initial appointments and not to promotions. The operation of the roster for filling the cadre strength by itself ensures that the reservation remains within the ceiling limit of 50%. In our view, appropriate government has to apply the cadre strength as a unit in the operation of roster in order to ascertain whether a given class group is adequately represented in the service. The cadre strength as a unit also ensures that upper ceiling limit of 50% is not violated. For the roster has to be post-specific and not vacancy-based. This is reiteration of what was said by the Constitution Bench on 10th February 2015 to 1995. Then, my lords, proceeding further at paragraph 92 at page 679. Again, Nagaraj takes us back to R.K. Sabharwal, para 92, my lords. Page 679.
Yes.
In R.K. Sabharwal, the issue was concerning operation of roster system. This court stated that the entire cadre strength should be taken into account to determine whether reservation up to the required. It was held that if the roster is prepared on the basis of cadre strength, that by itself would ensure that the ceiling limit of 50%, the reservation would remain within the ceiling limit of 50%. In substance, this court said that in case of 100-point roster, each post gets marked for the category of the candidate to appoint against it, and any subsequent vacancy has to be filled up by that category alone. Replacement theory. Proceeding but at paragraph 96, my lords, 96 at page 6981. The Constitution 81st Amendment gives, in substance, legislative assent to the judgment of this court in R.K. Sabharwal. Once it is held that each point in the roster indicates a post which on falling vacant has to be filled up by the particular category of candidate to be appointed against it, and any subsequent vacancy has to be filled by that category alone, then the question of clubbing the unfilled vacancies with current vacancies does not arise. Therefore, in effect, Article 16(4)(b) grants legislative assent to the judgment of R.K. Sabharwal. If it is within the power of the state to make reservation, then whether it is made in one selection or deferred selections is only a convenient method for implementation, as long as it is post-based, subject to replacement theory, and within the limitations indicated hereafter. Then, my lords, carrying the discussion forward at page 683. Para 102, while answering the question whether the impugned constitutional amendments violate the basic structure. Notice, 102, in the matter of application of the principle of basic structure, twin tests have to be satisfied, namely the width test and the test of identity. As stated here in above, the concept of catch-up rule are not consequential constitutional requirements. Their concept derived from service jurisprudence. Then, my skip about 5 lines. Then, clause 4 of Article 16, however, states that the appropriate government is free to provide for reservation in cases where it is satisfied on the basis of quantifiable data that backward class is inadequately represented. Therefore, in every case where the state decides to provide, there must exist 2 circumstances, namely backwardness and inadequacy of representation. As stated, equity, justice, and efficiency are variable factors. These factors are context. There is no fixed yardstick to identify and measure these factors. It will depend on the facts and countries. These are the limitations on the mode of exercise of power by the state. Page 685, page 686, my lords. 107, para 107. It is important to bear in mind the nature of constitutional amendment. They are curative by nature. Article 16.4 provides for reservation for backward classes in cases of inadequate representation in public employment. Article 16.4 is enacted as a remedy for the past historical discriminations against a social class. The object of enacting the enabling provisions like 16.4, 16.4a, 16.4b is empowered to identify and recognize the compelling interest. If the state has quantifiable data to show backwardness and inequity, then the state can make reservations in promotions, keeping in mind maintenance of efficiency, which is held to be a constitutional limitation on discretion of the state in making reservation, as indicated with, as stated above. The concepts of efficiency, backwardness, and inadequacy of the required representation are required to be identified and measured. That exercise depends on availability of data. It is on a post-based reservation. The concept of adequacy has to be tested on post-based roster. Next page, Manos, in the paragraph 107, about 10 lines from bottom, Manos. However, when the state fails to identify and implement the controlling factors, then excessiveness comes in, which is to be decided on the facts of each case. In a given case where excessiveness results in reverse discrimination, this court has to examine it and decide the matter. Which, therefore, my lords, the Nagaraj test is adequacy has to be tested on the basis of post-based roster, which has not even been implemented in the state, even after 3 decades of R.K. Subbarwal. Para 110, minutes at page 688.
Yes.
As stated above, the boundaries of the width of the power, namely the ceiling limit of 50%, the numerical benchmark, the principle of creamy layer, the compelling reasons, namely backwardness, inadequacy of representation, and the overall administrative efficiency are not obliterated by the impugned amendments. At the appropriate time, we have to consider the laws enacted by various states providing for reservation if challenged. At that time, we have to see whether limitations on the exercise of power are violated. The state is free to exercise its discretion providing reservation subject to the limitation, namely that there must exist compelling circumstantial reasons for backwardness, inadequate representation, a class of posts keeping in mind overall administrative efficiency. It is made clear that even if the state has reasons to make reservation, as stated above, if the impugned law violates any of the above substantive limits on the width of the power, the same would be liable to be set aside. Thereafter, at 116, page 692, again, my lords, the reservation should meet the tests of classification, and Article 14 cannot be obliterated. That is what is stated. As stated above, Article 14 enables classification. A classification must be founded on intelligible differentia, which distinguishes those that are grouped together from others. The differentia must have a rational relations to the objects sought to be achieved by the law under challenge.
In Indrasani, opinion was expressed by this court, paragraph 802, that there is no constitutional or legal bar to making of classification. Article 16(4)(b) is an enabling provision. It seeks to make classification the best differential between current vacancies and carry forward. Rest of it deals with the carry forward, which we are not concerned with here. But again, at page 693, it said Article 16(4)(b) is a direct consequence of the judgment of this court in RKS Sabharwal, by which the concept of post-based roster is introduced. After saying all this, the conclusions are reached from paragraph 121 onwards. 121, I just leave that, except reading one paragraph, that is 121 at page 695. It said, the important constitutional amendment by which Article 16 have been inserted flow from Article 14, 16(4). They do not alter the structure of 16(4). Article 16. They retain the controlling factors of compelling reason, namely backwardness and inequity, which enables the state to provide us in keeping with overall efficiency. These improved amendments are confined only to SCs and STs. They do not obliterate any of the constitutional requirements, namely ceiling of limit of 50%, quantitative limitation, concept of creamy layer, qualitative limit exclusion, subclassification of OBC on one hand and SCs on the other hand, as held in Indrasani, the concept of post-based roster with inbuilt complex concept of replacement as held in RKS Sabharwal. This is the conclusion. And insofar the central government is concerned, the central government has implemented this direction as early as on 2nd July 1997. I am passing on to the post-based roster that is introduced and the principles set out therein also. The principles of operating post-based roster you may also would kindly take the explanatory note there to the OM dated 2/7. That is the top page mark 1, 2, 3 is the page number marked at the right hand top corner.
Yes.
There note 2, the model rosters have been drawn up keeping in mind two fundamental principles. The reservation for the entitled categories is to be kept within the prescribed percentage of reservation, and the total reservation should in no case exceed 50% of the cadre. There should be separate rosters for direct recruitment and for promotions, where reservation in promotion applies. Then note 6, as indicated in the model roster, the method for making a roster is to multiply each post by the prescribed percentage of reservation for the different reserved categories. The point at which the multiple for a community obtains a complete number or overstep the number is to be reserved for that community. Here, they say reservation for SC is 15%, but they reserved first roster point to the SC. And again, third roster point again. And third roster point is reserved for ST, even when they say that it is 7%. If it is 7%, the point that first occurs is 14th point. This is another way that they are taking the reservation even beyond what is set out in the Act itself. Then, my lords, the item note 8, it would be noted that at the end of the roster, squeezing has been done for the reserved categories to reach the number of posts to be reserved for them without violating 50% limit laid down by the courts. While drawing up, the cadre controlling authority should similarly squeeze the last points of the roster. Such squeezing may not, however, be done where it would violate the rule of 50%. Whenever there is any increase or decrease in the cadre strength, the roster shall be correspondingly expanded or contracted. The same will also apply whenever there is a change in the recruitment rules which affect the proportion of the posts to be filled by a particular mode of recruitment. The roster is to be operated on the principle of replacement and not as a running account. Under the roster, the state has prescribed by 28/12/2022. Even now, they operate it as a running account, which was held to be impermissible in R.K. Sabharwal. Then, my lords, explanation 12 takes care of the smaller cadres, where the cadre strength is 13 or less. And now, my lords, by virtue of the interim order passed by this honorable court, that they shall operate reservation within 50% limit. They have revived during the interregnum 1995 roster, which is again a vacancy-based roster and not a post-based roster. These are the submissions I would like to make, my lords. Yesterday, my lords asked me a question as to which are the cases where reservation in excess of 50% have been approved by the courts. Now, my lords, I have tried to analyze, my lords, the first excess exceeding 50% exercise was made by the Tamil Nadu legislature. Yes. That is, my lords, the Tamil Nadu legislature made an enactment called, this is, my lords, 1994 Act. That 1994 Act was made after obtaining the assent of the President to enable it to be included in Schedule 9. Sorry, Schedule 9. This act was notified, my lords. Copy the. I'll have only one copy, my lords. I'll pass on the copies. Yes. That is called, they called it as, my lords, the Tamil Nadu backward classes, scheduled castes and scheduled tribes, reservation of seats in educational institutions and of appointments of posts, 1993. Thereafter, my lords, by constitutional 76th amendment, 9th schedule was amended by insertion of this act at entry 257 capital A, my lords. Constitution. Yes. 257 capital A, it was inserted to put it in the 9th schedule so that the benefit of Article 31 capital B to validate the law could be utilized. Thereafter, my lords, after this insertion, Constitution Bench, my lords, in Vaman Rao held that Vaman Rao versus Union of India, 1981, 2 SCC 362. It held, my lords, by insertion of an enactment into 9th schedule, no immunity from judicial scrutiny is granted insofar as enactments or insertions made after the date of judgment in Keshavananda Bharati.
Then once a doubt was raised about this proposition, saying that in Bhim Singh Ji, a separate, different view has been taken. Then to resolve all these matters, the matter was referred to 9-judge bench. That is, my lords, I will pass on to my lords the judgment of the 9-judge bench, which is in IR Coelho, my lords. Only 3 paragraphs from this judgment I would read, my lords, what is the present position. That is paragraph 4 at page 69 of the judgment, my lords. Page 69.
Yes.
In the referral order, the Constitution Bench observed that, according to Vaman Rao versus Union of India, amendments to the Constitution made on or after 24/4/1973, by which the 9th schedule was amended from time to time by inclusion of various acts, regulations therein were open to challenge on the ground that they or any one or more of them are beyond the constituent power of the Parliament, since they damage the basic or essential features of the Constitution or its basic structure. The decisions in Minerva Mills Limited, Bhim Singh Ji were also noted, and it was observed that the judgment in Vaman Rao needs to be reconsidered by a larger bench so that the apparent inconsistencies therein are reconciled, and it is made clear whether an act or regulation which or a part of which is or has been found by this court to be violative of one or more of the fundamental rights conferred by Articles 14, 19 and 31 can be included in the 9th schedule, or whether it is a constitutional amendment amending the 9th schedule which damages or destroys the basic structure that can be struck down. While referring these matters for decision to a larger bench, it was observed that preferably the matters be placed before a bench of 9 judges. This is how these matters have been placed before us. The fundamental question is whether on and after 24/4/1973, when the basic structure was propounded, it is permissible for Parliament under Article 31B to immunize legislations from fundamental rights by inserting them into the 9th schedule, and if so, what is its effect on the power of judicial review of the court? This was the question, my lords, and unanimous opinion rendered by the 9-judge bench, my lords, is at paragraphs 149 to 151 at page 110, my lords. Article 30, good my lords, para 149. Yes. Article 31B gives validation based on fictional immunity. In judging the validity of constitutional amendment, we have to be guided by the impact test. The basic structure doctrine requires the state to justify the degree of invasion of fundamental rights. Parliament is presumed to legislate compatibly with the fundamental rights, and this is where judicial review comes in. Greater the invasion into essential freedoms, greater is the need for justification and determination by court whether invasion was necessary, and if so, to what extent. The degree of invasion is for the court to decide. Compatibility is one of the species of judicial review which is premised on compatibility with rights regarded as fundamental. The power to grant immunity at will on fictional basis without full judicial review will nullify the entire basic structure doctrine. The golden triangle referred to above is the basic feature of the Constitution as it stands for equality and rule of law. The result of the aforesaid discussion is that constitutional validity of the 9th schedule laws and the touchstone of basic structure doctrine can be adjudged by applying the direct impact and effect test, the rights test, which means the form of an amendment which is not the relevant factor, but the consequence thereof would be a determinative factor. In conclusion, we hold a law that upgrades or abridges fundamental rights guaranteed by Part 3 of the Constitution may violate basic structure of the doctrine or it may not. If former is the consequence of the law, whether the amendment of any article of Part 3 or by an insertion of the ninth schedule, such a law will have to be invalidated in the case of judicial review, the power of the court. The validity or invalidity would be tested on the principle laid down in this judgment. The majority judgment in Keshavanand Bharati read with Indira Gandhi case requires the validity of each new constitutional amendment to be judged on its own merits. The actual effect and impact of the law on the rights guaranteed under Part 3 has to be taken into account for determining whether or not it destroys basic structure. The impact test would determine the validity of the challenge. All amendments to the Constitution made on or after 24/4/1973, by which the 9th schedule is amended by inclusion of various laws therein, have to be tested on the touchstone of the basic or essential features of the Constitution, as reflected in Article 21, read with Article 14, Article 19, and principles underlying them. To put it differently, even though the Act is put in 9th schedule by a constitutional amendment, its provisions would open to attack on the ground that they destroy or damage basic structure if the fundamental rights are taken away or abrogated pertain to the basic structure. Justification for conferring the protection, not blanket protection, on the laws included in the 9th schedule by Constitution shall be matter for constitutional adjudication by examining the nature and extent of infraction of fundamental rights by a statute sought to be constitutionally protected, and on the touchstone of the basic structure doctrine as reflected in Article 21 read with 14 and 19 by a synoptic view of the articles in Part 3 in applying the above test to the 9th schedule laws. If the infraction affects the basic structure, then laws will not get the protection of 19th. This is our answer to the question referred to us by the order dated 14/9. If the validity of the has already been upheld by this court, it would not be open to challenge such law again on principles declared by this judgment. However, if law is held to be a violator of any right in Part 3 is subsequently incorporated in the 9th schedule after 24/4/1973, such a violation infraction shall be open to challenge on the ground that it destroys or damages the basic structure as indicated in Article 21, read with Article 14, 19, and the principles underlying thereunder. Action taken and transaction finalized as a result of the impugned act shall not be open to challenge. Now, 1994 Act has been challenged by this before the Supreme Court, and the challenge to that enactment is pending before the Supreme Court, as noticed, my lords, in judgment in Pattali Makkala Kadchi, Volume 5. My lords, Volume 5, page 2261. The judgment commences at 2261. I have taken my lords to this judgment, but on this aspect, I have not pointed out the relevant paragraphs, my lords. What was struck down in Pattali Makkala Kadchi is 2021 Act, subsequent enactment of Tamil Nadu Assembly. But insofar as 1994 Act is concerned, that's at para 107 at page 2315. Last but one paragraph, my lords. We make it clear that we have not expressed any opinion on the merits of the writ petition challenge 1994 Act pending consideration before this court, or for that matter challenges to any other legislation which may have been referred to herein, and our findings are strictly confined to the issues which have come up for consideration in relation to 2021 Act. 94 Act is challenge is still pending before the Supreme Court because of there was some confusion, and ultimately it was cleared only in the year 2007. Thereafter, I don't know, my lords, why it is pending. But in so far as state of Karnataka is concerned, my lords, an executive order was passed in the year 1994, my lords. Judgment could be there. 97, 94, but it is referred to as a okay. It is the present act also is not placed in the 9th schedule. Yes. Yes.
But it says as executive order. Yes, yes. In a short judgment, my lords, that government order dated 25/7/1994 issued by the state government, which my learned friend says it was an enactment. I'm sure he should know better because he has been there on these issues. He has been arguing for quite some years. My lords, he must be knowing. In this, my lords, S.V. Joshi's judgment, first 7 paragraphs, first paragraph 3 to 7 deal with pending challenge to the 1994 Tamil Nadu enactment, where they say, my lords, para 6, consequently, these repeats are disposed of, etc. It needs to be interim orders passed by this in relation to admissions shall continue to be enforced and in operation for a period of 1 year from today. In this, we are not expressing any opinion on the validity of the 1993 Act at this stage. The registry is directed to send the records if that is for collecting the quantifiable data. It was sent back to the state, but keeping the writ petition pending in the Supreme Court. Para 8 onwards is about the Karnataka Act. By this writ petition, government order dated 25/7/94 passed by the state of Karnataka is sought to be challenged only to the extent that it provides for reservation in excess of 50%, both in the matter of admission to educational institutions and in the matter of recruitment to service. On 9/9/1994, the present writ petition had come up for directions along with IA number 4 in writ petition number 438. In this case, we are concerned only with writ petition number 471. On the said date, this court passed the order in following terms. State granted government shall be at liberty to make reservations in terms of the law laid down by this court in Indira Sahni's case.
No, but is this order available?
No, my lord, they have made an act. There are 12, my lords. By this writ petition, challenge is laid to sections 4, 5, and 7 of the Karnataka Scheduled Caste, Scheduled Tribes, and other backward classes, Reserved Act 1994. By an interim order dated 11/11/94, this court has stayed the operation of sections 4, 5, and 7 of the Act, which is in operation till date. It is not in dispute that after the filing of the writ petition and during its pendency, Article 15 and 16 have been amended by the Constitution Amendment, so and so. Further, after the filing of the writ petition, various pronouncements have been made by the judgments of constitutional benches of this court in M. Nagaraj, Ashok Kumar Tagore. Under the said decisions, which have been rendered in the light of Constitution 81st Amendment and 93rd Amendment, reservation exchange could be made only on the basis of quantifiable data before the government. It appears that till today this exercise has not been undertaken by and the state government has not collected the quantifiable data. It has not represented such data. In these circumstances, we hereby direct the state of Karnataka to revisit sections 4, 5, and 7. In the light of judgments of this court referred to above, we give 1 year's time if so advised. 1994 government order was set aside, and my lords, before the Supreme Court passed this order, state had introduced implemented that order, but then my lords, immediately after the interim order was passed, it stayed it. Thereafter, it withdrew that order. The executive order of 1994. Thereafter, my lords, the 50% reservation, excess of 50%. Yes, my lords.
This is an act of 1994.
Act of 1994 does not say only anything about the quantum of reservation. What it says is, any executive order that has been passed under Article 16(4) shall be treated as an order made under this Act. And thereafter, after 5/7/1994 experiment with the executive order, they did not make any executive order in excess of 50%. Instead, they brought this Act which has been implemented here. This has neither received by the assent nor included in the 9th schedule. Therefore, all that I told about the 9th schedule will not be applicable. Then, my lords, the similar effort was made by 2 states to exceed. One is, of course, Jayashree Lakshman Rao Patil, that is in respect to that is. 2 other states, Chhattisgarh and Bihar, both have been struck down by the Supreme Court. Those orders I have placed, there is, my lords, in Those are in volume 4, they are judgments 3 and 4.
Yes.
Only thing, two paragraphs I would like to point out from Bihar judgment, where Bihar enactment was struck down. Because there they have given comparative representation figures. In fact, from reference to annexure H in my petition, I pointed out that the representation of SCs and STs in the services of the state are far in excess of prescribed percentage. In Bihar, that percentage was much less than the percentage achieved in the state of Karnataka. Yet, my lords, it said that the act is bad because of various reasons stated. That is, my lords, if my lords would kindly turn to page 1803.
Give us a paragraph.
There is paragraphs 64, 65 minutes. And last, my lords, State of Jharkhand made an enactment in the year 2022, whereby it wanted to take the reservation to 77%. But the act itself said that it will come into force after its insertion in 9th schedule. But that act has not even been assented by the governor as yet. Therefore, it is still a bill passed by the legislature and reservation has remained at 50%. Therefore, I can submit, my lords, there is no state where it has been approved beyond 50%. Only 1994 Act of Tamil Nadu is that challenge to it is pending, but that may not affect our case because there the question involved is to what extent whether even after insertion into Schedule 9, whether it is protected or not. But here, there no such eventuality. There nothing. No such question would have. I'm grateful, my lords.
So some of these acts which are now under challenge before the Supreme Court have been then left to the courts.
But they are pending, my lords. Bihar judgment.
So Madhya Pradesh was one of the.
Madhya Pradesh Act. What has happened, my lords? Madhya Pradesh Act. The moment it was challenged before the High Court, it was stayed by the Madhya Pradesh High Court by judgment which said that. Except in respect of economically weaker section reservation, no other enhanced reservation shall be beyond 50% shall be implemented. Then, my lords, that judgment was taken in appeal to the Supreme Court. Supreme Court, my lords, remanded the matter and did not exercise its jurisdiction. Supreme Court said that this shall be considered by the state, by the High Court, and remanded the matter, and that is still pending, my lords. That is in Ashish Dubey, that interim order has been reported, my lords, in the Madhya Pradesh law judgment. Therefore, my lords, nowhere it is in operation is my lords. Grateful.
2:30, you want 1/2 day. You will say you wanted 15-20 minutes.
20 minutes.
I will give you tomorrow 20. Anybody who wants to argue from the petitioner side? All. You can take it in the
May I
time.
pass on that Ashish Dubey or judgment, my lords, in Madhya Pradesh? Could it be taken up on Friday?
Look, there we'll finish tomorrow. We will finish that tomorrow.
Please.
We look, or we'll give you next week and you finish after.
There.
That Janit judgment you have to give.
Janit is before the court. I have produced not
All right.
I have produced document. Judgment in your General Singh I have produced. Janhit Abhiyan I have.
The state is arguing supporting it. So where is
Janhit I have produced, my lords. I did not read the paragraphs, but what they say is that insofar as Article 15.4 and 16.4 is concerned,
50% ceiling stands.
We'll take it after next week. Put it after third, fourth week.